first case this morning is Haynes versus Ally Financial. Each part will have 15 minutes to make the argument. Ma'am, how long would you like to take for rebuttal? You may reserve up to 5 minutes. How long would you like to reserve? Have you thought about that yet?
I haven't. I knew I was going to speak and just reserve the rest of my time for my rebuttal.
We have 15 minutes total, so the most you can reserve for rebuttal is 5 minutes. We'd like to reserve that 5 minutes.
Yes.
And if you finish before that, that's okay. But so, and you look at the clock over there. When that gets down on the top of 5 minutes, that's when your rebuttal time will start. I'll try to give you a reminder about a minute before that comes up. Okay?
Thank you.
You're welcome. The arguments are being recorded. When you present your argument, please come up to the podium. Please make sure you introduce yourself. Stay behind the podium because we're visually recording it, and then that will help us also hear you on the audio recording portion of it. I don't think it applies in this case, but if you're referring to any victims or children or anyone, please make sure you refer to them by initials. I don't think we have that in this case to be concerned about. We've read your brief and are ready to proceed whenever you want. Yes.
Hi, everybody. My name is Dominque. They made me follow the Dominque Haynes, which is fine. We're here today to discuss what I believe to be an error in the trial court, which was I did state a claim upon which relief can be granted. I did state fraud with particularity, and the statement was plain and short. Ally Financial, or whatever name they're trying to use now, their alter ego, Ally Bank, they employed a company to take my car while we were in dispute. Inside that contract, there was a specific notice, and that notice, according to Ohio Revised Code, states that when that notice appears, there is no holder in due course of that instrument, which they are acting to be, which is totally out of character. I came to the court in order for them to, one, take possession of the vehicle until we could come to an end of the session. They failed to do that, and then they failed to understand me as a pro se litigant, although I was speaking plain, coded language, which they are required to know. And I would like to reserve the rest of my time for rebuttal.
No questions? Thank you. You may do so.
Oh, I'm sorry.
Oh.
I didn't ask you guys. Did you have any questions? Great. Sorry.
It's okay.
May I first, Judge?
Yes.
Good morning, and may it please the court. My name is Joel Seckler. I'm an attorney with Carpenter Lips in Columbus, Ohio, and I'm counsel for Ally Financial in the case. The trial court found that what Ms. Haynes alleged was that fraudulent misrepresentations were made to her by Ally Financial. What those fraudulent misrepresentations were never specified. Not even hinted at what the fraudulent misrepresentations were, and that's why the trial court found that a short and plain statement of what the alleged wrongdoing was not made in the complaint. And respectfully, I would submit the trial court got that correct. I did want to respond briefly to two things that Ms. Haynes said this morning. One is that Ally Financial repossessed the car. And without conceding that it was Ally Financial that did the repossessing, her car was repossessed. And in Ohio, you do not require a court order. Self-help repossession is the law of Ohio as long as the peace is not breached while the car is being repossessed. There's no allegations of breach of the peace anywhere in the complaint. And she also brought up again this morning something that has been a theme in the briefing is about the notice in the contract, which again, the contract isn't part of the record. I will just say that in contracts of this nature, there is a federal regulation notice that's required to be in it saying that the holder takes subject to any claims that the buyer of the vehicle, in this case Ms. Haynes, would have against the dealership. Assuming that that is the notice that she's referring to, I would agree. Ally, and if Ally is the holder, they are not a holder in due course with respect to any claims that she may have against the dealership. She could assert those claims as a right of set off against Ally. The issue is that within the four corners of the complaint, there's not even a hint that she's asserting any wrongdoing on behalf of the dealer.
What about the reference in the complaint to the federal and state consumer protection laws? That wasn't addressed in the court's order.
You are correct, Judge. And again, I would say to that what I said in the briefing is, that's just simply a conclusory legal claim. Just unspecified federal and state laws were violated. That's not a short and plain statement. That's not putting my client on notice of what they did wrong so they can defend it against it, decide what motions to file, decide what to do in terms of strategy in the case. And that's the point of Rule 8, is to alert the defendant specifically what the plaintiff is saying you did wrong, so that you can decide, both in a matter of litigation strategy and asserting your rights in litigation, how you are to respond to that.
So, counsel, your client filed a motion to dismiss pursuant to 8A, 9B, and 12B6. My reading of the trial court's entry is it was a dismissal only as to 8A. Do you read it the same way?
I think so, Judge. I don't know what was in the trial court's head specifically. Within the four corners of that, I think that may be right, though the judge does refer in her last full paragraph to the arguments I made about Rule 9B and not pleading fraud with specificity. And the court did find plaintiff provides no factual support to what, if anything, defendant did that would constitute a fraudulent misrepresentation. So if I could amend my earlier statement, I think the trial court was making the decision both under 8A and 9B.
Thank you.
On appeal, the plaintiff argued that she made a short, plain, concise statement regarding the claim for conversion. What would you say regarding that claim for conversion? I think the second page, he talks about the lien holder took it. You weren't a lien holder, you took it and you're keeping it.
Yeah, well, and I'll try to break that down, Judge, into two pieces. The first part of the argument is you're not a lien holder. Well, the only basis in the complaint for that statement is, again, that this federal regulation notice is in the contract. And that doesn't make Ally Financials, if they are a lien holder, that doesn't make their lien invalid, that just makes their lien subject to.
But is that a legal question? It's not an 8A problem, it's a 12B problem.
I would say that might be the case if there were some allegations of wrongdoing about the dealership within the four corners of the complaint. But since there isn't, then the notice is, if it's the notice that we're all thinking is being referred to, it's irrelevant, because there wouldn't be any claims against Ally for derivative liability pursuant to the notice unless there's claims of wrongdoing by the dealership. And there's no claims of wrongdoing by the dealership within the complaint. And then I think the second part of that statement was, the conversion part, Judge. Again, to be a lien holder and potentially liable to a conversion claim in Ohio, there must be an allegation not only that a repossession happened, but that repossession breached the peace. And there's no allegations of any breach of peace in the repossession of the car. She's simply saying, they took my car, I didn't want them to take my car, but there's no allegations that a breach of peace occurred during that process.
Any other arguments you have to make or any other comments? You also, I think, talk about replubbing. Where would her replubbing claim on the complaint fail?
Well, I guess for all of in addition to all of the reasons that we've talked about before, in order to state a replevin claim in Ohio law, you have to have an affidavit accompanying your complaint with all of the required elements of a replevin claim set forth. And that's, obviously that was not present in anything that she filed in the case, in addition to all the things that we've talked about before. The lack of, there's no pleading that the lien is invalid, there's no pleading that there was a breach of peace that occurred during the repossession. I mean, technically speaking, there's not even an allegation in the complaint that she's not in default on the contract. She's just saying this magic language inside the contract means Ally Financial can't enforce the contract and she gets the car for free. And she doesn't have to make any payments and they can't take the car from her. At bottom, that's what the complaint alleges, which does not state a claim under Ohio law. And so, Oh, the only other thing I wanted to point out is there's been, in the briefing, there's several references to her in the complaint that she sent a notice to commence suit to Ally twice, one in May of 2023 and August of 2023. And notices of commence suit are a peculiar creature of statute that deal with when people, someone has a lien on your real property, like a mechanic's lien. It's not a statute that applies to vehicles, and I think I made that clear in the briefing, but I did want to touch upon that this morning. But otherwise, unless the court has any further questions for me, I would ask that the judgment be affirmed, and I would yield the balance of my time.
Seeing no further questions, thank you.
Thank you, Judge. Thank you all.
No, please go.
So I do want to rebut, I heard that he said that that statement didn't apply to him, but the dealer is acting as seller creditor, and when they sign on, they're coming on as acting as lien creditor. And according to law, when you combine those, they take on all the liability as creditor. So that's what that states. Also, when you go to 1303.05D, it says specifically, if this statement is in an instrument, which that risk assessment was an instrument, and although he's claiming that it didn't, what part didn't apply to him, that the risk, I'm sorry for stuttering, a risk installment contract plan according to Ohio Revised Code is considered a real property instrument, and that's what we were disputing. The reason why it wasn't there, and as I told the court, I was asking them, and I asked the court to compel them to provide us with a copy so we could have it. They didn't, everyone ignored it. I ended up going to the dealer and finding them to actually get a copy for the second case that was filed, so we could have everything right. I find it disheartening that when I go through the Summit County courts, when their bar attorneys are submitting for replevin, this is how I learned about it, they often issue a statement and say, hey, you're missing an affidavit. Why didn't anyone help me? They often leave our indigent litigants with no help whatsoever, but they would supply all the replies to their bar members. Another thing I wanted to address, when I'm saying there can be no holder in due course meaning someone's expecting payment. So if they're expecting payment, Ally was expecting payment, and it says it can't be a holder in due course, they're acting fraudulently in misrepresentation in nature and character in which they are holding it. And they did breach the peace. I'm not sure if I said that, but I'm pretty sure I said that, and I'm pretty sure I stated I was Indian. So regardless of Ohio's laws of self-help repossession, it doesn't apply to us in the United States because we are supposed to be secure in our properties. And for the fact that I am Indian, and according to the Ohio auditor's book, we are actually mentioned there as historic Indians, as historic sovereigns. They needed the state's permission. They needed to file a replevin claim. They knew exactly what they were doing. They played on the law specifically because we're not a part of this bar association. That's what they did to me. They should have filed for replevin when I asked them to, so we could handle it civilly. Civil is first. It's not secondary to anything. And I made that very clear. They went around the law, and I do believe that they were helped in that process, because they played on our ignorance, or in this case, my ignorance. But, I did state a claim for conversion was only a small sentence. Form 10 is literally one sentence. One. I made many sentences. And not only that, I just expected more from the trial court to know when I was saying those rules in plain language to understand. And so maybe, I don't know who's incompetent here. Either we shouldn't be knowing our rights and our laws, or, if we can't interpret them, or you can't interpret what we're saying. So that's what I think what happened here. But everything was stated plain and clear. I would just ask that that if we could go ahead and do a reversal. I would like to try in the United States District where I feel that our rights would be better asserted. Maybe I just didn't feel that here in this case, but I highly believe she erred. That statement was plain. It only took one sentence in a Form 10, So many sentences, it shouldn't have took that much. I definitely told her who I was. I definitely told her I was Indian. You know you can't take property from us without the consent of a court of competent jurisdiction. They know that. The world knows that. It's a plain law. And that's all I have to say.
Thank you, ma'am. The court will take the matter under advisement. Will issue a decision in due course. That will be mailed to you by the clerk of court when it's released. Also be released on the High Supreme Court website as well. With that, I'd like to thank both of you for your presentation